who's a criminal law expert who's been following the Oscar trial closely. He joins us now from our studios in Bloemfontein. Thank you very much indeed for joining us and welcome to the programme. Perhaps I can start by just getting your impressions on what happened today. It would seem that facing a full bench is quite a robust experience.
Yes, of course. It's never easy to appear in front of the Supreme Court of Appeal in Bloemfontein. Relentless questioning sometimes takes place, and I can safely say tonight that Barry Roo and Retrial both can attest to that aspect. But yeah, all in all, it was nothing extraordinary. This is typically what happens in the SCA in Bloemfontein. Both parties are taken to the task, and they have to explain why they came to the conclusion in their heads of arguments the way they did, and obviously persuade the judges, for all time's sake, to give a verdict in their favour one way or another. At the end of the day, taking into consideration the day's event, it seems, on face value at least, that Advocate Retrial for the state had a good day in court. Barry Roo, on the other hand, he had a lot more explanation to do, which he did, and whether he was successful in that, only time will tell, obviously.
So if you could just take us through briefly, what was the thrust of Advocate Nell's argument to try and reverse the conviction from culpable homicide to murder?
Well, first of all, there were the two issues that came about from the outset, and that was the jurisdictional issue, first of all, which everybody seemed to agree on. There was reference made to case law like State versus Sekwe and State versus Basson and so on. And then there was the second leg of the test, and that was whether this is a question of error in law or error in fact. After that's been concluded, then Advocate Retrial, on behalf of the state, contended that basically Judge Masipa erred in her verdict on two aspects. First of all, the fact that she did not take into consideration circumstantial evidence. The whole debate regarding the evidence of ballistic expert Mangena came about. That is the first issue. The conclusion being reached, if he was such a wonderful witness as concluded by Judge Masipa, why didn't she take into consideration the evidence that he provided to court? Simultaneously with that, also the second leg of the argument by Advocate Retrial, and that is to say, but listen, Judge Masipa erred in her determination of the definition of what we call dolus eventualis, which is actually an element of guilt, which is obviously, in terms of the law, a requirement for a conviction on a murder charge.
Is the burden of trying to convince the bench much higher for the state than it is for Barry Roo?
Indeed it is. One must be mindful of the fact that there is a verdict that's already in existence. So any party that wants to overturn such a conviction must persuade the judges of appeal that the initial verdict was materially incorrect. Therefore, the onus of proof is heavily on such a person. In this instance, obviously on the state, being represented by Advocate Retrial. But if one takes cognizance of the fact that he was on his feet for maybe an hour and a half in comparison to Advocate Barry Roo, having to face the music for more than 2.5 hours, it might be indicative, at least from a layman's perspective and an objective opinion out there, that Retrial got the better end of the day.
So the judges go away, they're considering what to do in terms of coming up with the decision. What choices do they have in terms of what happens next?
Well, obviously they can concur with Judge Masipa's verdict, in which event the appeal will be dismissed with costs in favour of the defence against the state. That's the one option. The other option is obviously then to overturn the verdict by Judge Masipa, and for argument's sake then let's assume exclusively confine ourselves to the culpable homicide charge, in which event they might substitute that charge then with a murder conviction. Indications in court came out that they might then be inclined to refer the matter back to Judge Masipa to then reconsider sentencing, but this time around on a murder conviction, implying that she will have to attend to mitigating and aggravating circumstances and evidence again, in addition to what she already attended to previously, and then sentence Oscar Pistourius accordingly. Also taking in consideration the minimum sentencing act applicable where murder convictions are up there, which means that Oscar Pistourius might then go in to prison for between 15 and 20 years. Obviously, the judge will have a discretion to deviate from that minimum sentence in her discretion, depending on whether there are compelling and substantial circumstances to deviate from it.
All right, very briefly, they did talk about a retrial. It seems extreme, but it's not impossible.
No. Obviously, there have been precedents in the past where the Supreme Court of Appeal have declared a trial, set it aside and directed that the retrial takes place. One does not like the idea, purely from a practical point of view. Forget about anything else. The mere time, energy, and finances involved speaks for itself. But they had the opportunity to peruse the documents, the record. Everything is in front of the judges. They have perused it all along. They have studied it. There's no reason why they cannot merely substitute their own Judge Masipa's verdict with the one which they think is the correct one, whatever that might be.
All right, and that's where we'll leave it, and a story I'm sure that the whole world is watching. But thank you very much for your insights this evening, Dr. Llewellyn Curlewis.